Good morning, everyone. My name is Denise Katz, and I'm the Director of Legal Initiatives at the Louis D. Brandeis Center for Human Rights Under Law. I want to welcome everyone to our program today entitled Fighting Anti-Semitism in K-12 Schools. Thank you for joining us. On behalf of the Brandeis Center, I want to express our sincerest gratitude and appreciation to our honorary host, Congresswoman Debbie Wasserman Schultz, as well as her office for enabling our program to take place today. We are grateful for the opportunity to discuss this increasingly pressing topic with all of you today. I want to acknowledge also the Brandeis Center's clients who have traveled here from North Carolina and New York. Thank you not only for making the effort to be here today, but also for your courage and strength in coming forward to share your experiences. In doing so, you are not only helping to highlight a serious and disturbing problem that must be addressed and rectified, but hopefully you will also help ensure that in the future, other children, teachers, and staff in our K-12 schools don't have to endure the difficult experiences that you have been through. The Louis D. Brandeis Center for Human Rights Under Law is an independent, unaffiliated, nonprofit corporation established over a dozen years ago by Kenneth, the former Assistant Secretary of Education for Civil Rights. The mission of the Brandeis Center is to advance the civil and human rights of the Jewish people and promote justice for all. The Brandeis Center engages in research and legal advocacy to combat the resurgence in anti-Semitism on college and university campuses in K-12, in the workplace, and elsewhere. We empower students by training them to understand their legal rights, and we educate administrators and employers on best practices to combat racism and anti-Semitism. The bulk of our work at the Brandeis Center over the last dozen years or so focused on the college campus. But increasingly and horrifyingly, we have had to deal with similar problems in elementary and secondary schools as well. We have had over the years a case or two here and there involving anti-Semitism in K-12 schools. But since the Hamas terrorist attacks on October 7th, anti-Semitism in K-12 schools has exploded to the point where the virulence and extent of the problem resembles what we saw in higher education several years ago. Some of the anti-Semitism we are seeing in elementary and secondary schools involves traditional and classic manifestations. Some of it resembles what we are seeing in higher education, with middle and high schoolers emulating older siblings to target Jews on the basis of their shared ancestry connected to Israel. And some aspects of the problem are different, coming from teachers' unions or school-generated problems with curricula. Our panel today will provide an overview that touches on some of these aspects of the anti-Semitism problem in K-12 schools. We hope our program today will generate further interest and discussion of these important issues, and we welcome your questions after our panelists have concluded their remarks and after today. Our first speaker on our panel will be Marc Goldfeder, Senior Counsel at the Brandeis Center. Marc is also the director of the National Jewish Advocacy Center, and in his practice, he handles anti-Semitism matters around the country and the world. He also works with local, state, and federal legislators on measures to support the Jewish community. Marc has served as the founding editor of the Cambridge University Press Series on Law and Judaism and has taught law across the United States and internationally at numerous universities. Today, Marc will provide an overview of the laws that protect Jewish students from anti-Semitic discrimination in the K-12 context, and he will discuss the Brandeis Center's legal action against Origins High School in New York. After Marc, our next panelist will be Marci Miller. She is Senior Education Counsel at the Brandeis Center. Marci is a partner in the Litigation, Government Investigations, and Education Practice Groups at Potomac Law Group. Prior to joining the Potomac Law Group, Marci practiced litigation and employment law at Gibson, Dunn & Crutcher and Pillsbury Winthrop Shaw Pittman LLP. She founded Miller Advocacy Group PC, a public interest law firm specializing in high-impact litigation and education law. Today, Marci will provide an overview of the problems we are seeing in California's K-12 public schools, including several pending legal actions brought by the Brandeis Center. After Marc and Marci conclude their remarks, I will discuss the Brandeis Center's pending Title VI complaint against a North Carolina public charter school, which is currently under investigation by the Education Department. After my remarks, I'll be happy to invite questions from the audience for our panelists. So without further ado, I'll turn things over now to my colleague, Marc.
Thank you, Denise. Good morning, everyone. Thank you all for coming. By way of background, I just want to talk a little bit about some of the laws that protect Jewish students in institutions that take federal funding. Title VI of the 1964 Civil Rights Act provides that institutions that take federal funding cannot discriminate on the basis of race, color, or national origin. Now, you'll notice that religion is not among the list of protected classes under Title VI. And there are reasons for that, including various carve-outs for religious institutions and schools. But what that meant in practice was that for the first 40 years of its implementation, the Department of Education's Office of Civil Rights, which is in charge of enforcing Title VI, did not protect Jewish students from complaints about anti-Semitism because they considered Jews to be a religious group and really nothing else. In 2004, in a series of Dear Colleague letters that were written by the Brandeis Center chairman and then Assistant Secretary for the Department of Education in charge of the Office of Civil Rights, Ken Marcus, and what's now become known as the Marcus Doctrine, the Office of Civil Rights reversed course. And they said, you know, we actually are going to protect Jewish and Arab students to the extent that the charges of anti-Semitism also implicate ethnic or ancestral bias. Even if they share a religion, there's no reason they shouldn't get protection from that. And the truth is, the logic behind that is fairly simple. The vast majority of anti-Semitism that we see on campuses or in K-12 has nothing to do with whether or not a person does or does not light Shabbat candles or put on tefillin in the morning or do any other Jewish ritual. The vast majority of them have to do with a real or a perceived connection to the State of Israel, a race or national origin claim. And so the Department of Education in 2004 began to enforce Title VI for anti-Semitism complaints. But there still remained an important deficiency in the Department of Education's ability to enforce Title VI, namely the definition of anti-Semitism. Right? As many of you know, Jewish identity is multifaceted. It has elements of race, religion, ethnicity, national origin, etc. And because of that ambiguity, it was too easy for anti-Semites to commit heinous acts of anti-Semitism and then claim that it wasn't anti-Semitism because it wasn't based on this or that particular characteristic. And so even after 2004, it was incredibly difficult for the Department of Education's Office of Civil Rights to really get a handle on anti-Semitism cases. Until 2019. In 2019, again, with some of the help from the Brandeis Center's chairman, the federal government, through Executive Order 13899 under President Trump, decided to adopt the International Holocaust Remembrance Alliance, otherwise known as the IHRA definition of anti-Semitism. You may have seen that in the news this week because a wide bipartisan majority of the House just this past Tuesday voted to actually codify that executive order as law. And what that executive order said was very simple. When the Department of Education is assessing a claim of discrimination under Title VI involving a claim of anti-Jewish discrimination, when there's an allegation that the target was chosen because of an aspect of their Jewish identity, the Department of Education should consider the IHRA definition, which is the world's gold standard definition of anti-Semitism. The IHRA definition was developed in the early 2000s by the International Holocaust Remembrance Alliance, which is a non-governmental agency dedicated to Holocaust issues. And in the early 2000s, with the rise of anti-Semitism, they realized that never again has to begin always with early detection, and that you cannot fight a problem that you cannot define. And so they convened a group of experts across a number of different countries and a number of different fields and subtopics, and they developed this working definition, which the United States began to use as early as 2006, 2007, unofficially adopted in 2010, and officially adopted through the State Department in 2016 after it was voted on by the plenary of the IHRA, which included then 31 countries. So the IHRA definition has been adopted now by over 1,100 different important institutions, including, I think the current count is 36 of the United States and various departments of the federal government. Just to give you an example of how non-controversial this definition really is, there are very few things that the Bush, Obama, Trump, and Biden administrations have all agreed on, and this definition is one of them. It might be the only thing. but it really should not be controversial. To the extent that it is somewhat quote-unquote controversial, it is because the IHRA definition also includes examples of the kinds of anti-Israel sentiments that can cross the line into anti-Semitism. Now, the IHRA definition is clear. It has a savings clause which says that criticism of Israel, like that leveled against any other country, is not anti-Semitism. It's literally in the definition. But there are ways that you can demonize, delegitimize, or apply double standards to Israel that do cross the line. The Department of Education does not police speech. Title VI only regulates conduct. So the way that the executive order works is like this. Anyone can say whatever they want about Jewish students, but if it becomes severe and pervasive enough that it prevents people from engaging in the educational opportunities that they are entitled to, that is no longer speech. That is verbal conduct, and conduct can be regulated. And the Department of Education says that if you want to take federal funds, you have an affirmative obligation under the law to make sure that everyone in your program, including Jewish students, has a free from harassment environment in which they can learn and flourish. So that's the background to the Executive Order 13899, and that has been in place since 2019. So any school or school district, whether it's a college, university, K through 12, that takes federal funding, in general every year they sign a Title VI affirmation which says that they will abide by all the regulations under federal law in order to receive their funding, which includes making sure that under the IHRA definition, Jews are protected from anti-Semitic harassment and discrimination. To the extent that they don't, a complainant can file with either the OCR or with the federal court and ask them to give that money back. Okay, that's sort of the background of Title VI and the standard that it uses. Now, unfortunately, I'm sure many of you have seen the horrible things that are happening on campus right now. It's unreal. I never thought we'd live in a time where Jewish students and faculty are afraid to walk on campus. And I added faculty there, and it's important because I want to acknowledge, again, some of our clients who are here are not children. They are faculty members, they are teachers, they are administrators in schools, and they are protected under a different part of the 1964 Civil Rights Act, Title VII, which covers employment. What are we seeing in K through 12? Well, unfortunately, we are seeing that anti-Semitism it's a learned behavior, and by the time people get to universities, they may be fully baked, but they're learning that behavior earlier and earlier. I'll talk about a case that I handled a while ago in Georgia, in Fulton County. There were 2 Jewish students, I believe they were in 9th grade at the time, special needs students, and they were so viciously harassed, anti-Semitically harassed for 18 months that one of them actually became suicidal. Thank God his mother caught him before anything happened. But here's what happened. First, kids began to draw swastikas on the walls. And the school said, those aren't swastikas, those are Hindu peace symbols just at the wrong angle. Then they wrote, kill the Jews under the swastikas. And they said, that's just kids being kids. Then they started to throw things, including bags of money and pennies, hard things, at the children to hurt them. And they said, oh, those are just pranks. The school did everything that they could, because you're probably thinking to yourself, how hard is it to spot anti-Semitism? Well, let's take a step back for a second. A recent study found that almost half of adult Americans do not know what the word anti-Semitism means, and those are only the ones who are willing to admit it. Another study found that of the 11 most common anti-Semitic tropes, a large part of the country believes more than half of them, and there are more people who believe all of them than there are Jews in the world altogether. So, charitably speaking, people don't know what anti-Semitism is, and less charitably speaking, people don't care or actually believe in the anti-Semitic tropes that are causing these problems. Now, thankfully, in Fulton County, eventually, we stepped in and told the school district that they were going to face losing their accreditation and their funding, and those children were safe. But it never should have come to that. It never should have been that kind of a problem. And it used to be that K through 12 was a much less problematic area than universities. It's not like that anymore, and the Brandeis Center is handling multiple cases in the K through 12 space as we speak. Marci will talk about one. I will briefly talk about Origins High in New York. And the reason that I'm only going to talk about it briefly is because there is some development, which is we are actually planning to file a lawsuit imminently in that case, and I plan to let the filings speak for itself. But by way of background, I will just tell you that Origins High in New York has not been a safe place for Jewish people for a number of years. A number of students have had to request safety transfers because they did not feel comfortable going to school in the morning. Let that sink in. A number of students in today's day and age could not safely go to school because they were in fear of the kind of harassment, including physical harassment, that they would face from their peers. And the school knew about it, and the school did nothing about it. But it wasn't just students. In the audience today, we have two of our clients. We have Danielle Kaminsky and we have Michael Beaudry. Danielle is a teacher who worked at Origins High for several years. Michael Beaudry is a former assistant principal and safety campus administrator. Both of them complained to the administration about the anti-Semitism that they were seeing, that Danielle was facing, that Michael was reporting, and the administration did nothing for a while. Then the administration did do something. They began to retaliate against our clients for daring to stand up for anti-Semitism. And so they approached the Brandeis Center, and together with our partner law firms, including the Walden Mock law firm, a representative of which is here with us today, Mark Armis, we are planning to file a lawsuit to vindicate their rights. That lawsuit will be under different titles, under Title VII, under Section 1981, which protects equal employment, but we are also planning to file under Title VI to protect the students who are in Origins High. I'm going to share with you a couple of the allegations that we are planning to make, and I just want to give you a sense of what it looks like in practice. Among the many concerns here, and it's important to note, under Title VI, we are not targeting the students who committed the infractions, okay? We are targeting the administration who did nothing to stop them. So among the many concerns there are the school's dismissal and or failure to properly record and deal with reported incidents of anti-Semitic harassment directed at the students and the faculty, its failure to address offenders effectively, including through discipline and its enforcement, and its failure to timely implement a safety plan for the students and the faculty, or even to maintain adequate documentation of the reported incidents of harassments. It also involved its leadership's double standards when it comes to dealing with Jewish students and Jewish faculty. And so we at the Brandeis Center feel very, very strongly that no Jewish student and no Jewish faculty member, and the truth is no one of any race, color, or creed, should ever, ever feel unsafe going to school. And the federal government has made a commitment that they never should have to. And so we are here to make sure that the federal government lives up to its ideals, and that we hope the universities and the K-12 groups that we are dealing with will also live up to theirs. Thank you.
Good morning, everyone, and thank you for being here. My name is Marci Miller, and I practice in California, where anti-Semitism in the K-12 context has really taken hold and grown dramatically and drastically since October 7th, and was there well before that. As Mark said, every student in America has the right to a public school education that's free from discrimination and harassment. But in California K-12 schools, Jewish students are increasingly facing a hostile environment where they're actually scared to go to school. And we're seeing this particularly in the Bay Area in California. Students are scared and marginalized. At Berkeley Unified, for example, Jewish students are reporting that they need to hide their Jewish identities at school to avoid being harassed in the hallways, the playground, and even in the classroom by their teachers. Students at Berkeley have reported calls to kill the Jews, to eliminate Israel in the hallways. They report being asked what their number is, referencing the Nazi concentration camps. And Jewish students have been bullied based on their appearance, being told, "You have a big nose because you are a stupid Jew, and I do not like you people." And this all happened recently, since October 7th. Students in California public schools rely on their district personnel to protect them from harassment and discrimination, and Title VI is intended to protect these Jewish students. But anti-Semitism has now reached an alarming rate in California K-12 schools, particularly, as I said, in the Bay Area. School officials in California are setting a particularly dangerous tone at the top that allows anti-Semitism to flourish and actually makes students feel that it's perfectly fine to bully their peers and actually commendable at times. Jewish students endure anti-Semitic and anti-Israel class materials, with teachers using unauthorized and unlawful instructional materials that deny Israel's right to exist and include anti-Semitic tropes. Outside groups such as the Arab Resource Organizing Center, or AROC, access students on campuses in violation of district rules and the law for purposes of organizing student protests, student walkouts, and promoting their own propaganda, and to encourage students to participate in rallies where violence against Jews is promoted. This is happening primarily in San Francisco, Oakland, and the Berkeley school districts. In Berkeley and Oakland, teachers and AROC organizers led students as young as 11 years old off campus in October to walk out for Palestine. This was done without any prior parental permission and without regard to the safety of the Jewish children who were left behind in the classroom without any teachers or any instruction. The anti-Semitic rhetoric by adults in the California schools encourages and glorifies anti-Semitic harassment and bullying. This has all led to dozens of parents pulling their kids out of certain school districts, even in the middle of the year, to escape further persecution. Jewish students are routinely moved out of certain classes due to anti-Semitism. The students are inconvenienced, but the teachers are not told to change. Schools and classes are becoming segregated because administrators would rather remove the Jewish students than discipline the teachers. In short, school officials are failing to respond to complaints of severe anti-Semitism and are outright failing to allow Jewish students equal access to educational opportunities. Bullying and harassment of Jewish children at school doesn't happen in a vacuum. It's been fostered by teacher unions, teachers, and administrators who allow hateful, inappropriate, and discriminatory teachings in the class to kids as young as kindergarten. When students hear their teachers and other authority figures regularly spew anti-Semitic tropes, or when adults come to campus who are trusted and they organize hateful protests or rallies, children learn that this is perfectly acceptable to bully and harass their Jewish peers. And Jewish students feel shame in their heritage and a fear of bullying, and this makes them hide who they are in school. In the last 6 months, Jewish students in Berkeley, California have heard "F the Jews, kill Israel," and calls of KKK in front of district staff, and have seen "Kill the Jews" and "Kill all Zionists" written in graffiti in a school hallway and bus stop. A student whose mother filed an anti-Semitism complaint with the Office of Civil Rights woke up the next day to a social media post by an older student that had gone viral, saying that the Jewish student whose mom filed the complaint had lied because this student loved genocide so much and accused him of harming the school community by filing the complaint. And this is all because he stood up to anti-Semitism in his school. And this student now reports feeling unsafe and socially ostracized in his school. This is an obvious case of cyberbullying that in any other situation would have elicited at least a statement by school administrators denouncing hate. And guess what happened to the students who said all of these things that I just mentioned? Absolutely nothing. The mother of the student who was bullied on social media begged the school for measures to protect her son. Even just a statement saying that further behavior of this type would not be tolerated or that it would be investigated and punished, and her pleas were completely ignored. She was met with silence. Another Berkeley Unified mother who reported that her 6-year-old son was told Jews are stupid on the playground was told that anti-Semitism was not on the principal's radar at that moment. And this was shortly after an OCR complaint for anti-Semitism had been filed with that district. Recent school board meetings in California have turned into vicious attacks, especially in Berkeley and Oakland, where parents and teachers and members of the public shout anti-Semitic tropes and insults without board members intervening. At one recent board meeting in Berkeley, a parent shared incidents about bullying, including being called a kike and a dirty Jew. The members of the public in attendance at that board meeting laughed and jeered, and someone shouted, "Zionist, Nazi bitch," at the mother. The board members did not step in to control the public or protect the Jewish mother, and when the parent reached out to the school administration about this, she has not received any response. Board meetings have become war zones of their own, with harassment of Jewish parents who have the right to participate in these public meetings and to be involved in their children's education. But the attempts to intimidate Jewish parents from attending has worked. Most do not want to put themselves through the abuse time and time again. And something particularly frightening, some of the teacher unions are endorsing the removal of any Zionist board members at local school districts, as well as other public officials who are Zionist, by which they mean Jewish. Public officials who are Jewish or merely support the rights of Jewish students are harassed at meetings at their homes and followed by anti-Semitic mobs. And the unions have the right to endorse a candidate for school board. And their goal is a situation where public office in the area is completely Jew-free, like Nazi Germany was. And at this point, anti-Semitism will go completely unchecked in these school districts. In response to multiple complaints, against one particular teacher at Berkeley Unified School District for anti-Semitism, the teacher was placed on leave. However, teachers, students, administrators, and parents began openly advocating for this teacher's return. They placed flyers all over the school supporting the teacher who'd been put on leave for anti-Semitism, brought signs to school board meetings demanding his return, and the principal of that school even gave this teacher a shout out in the school newsletter after he'd been placed on leave. Some parents from Berkeley Unified will be present next week when the superintendent of Berkeley Unified School District will testify in front of the House Committee on Education and the Workforce. The superintendent has repeatedly said that she wants the district to be a safe place for all students to learn, and these parents are interested to see how she plans to make it safe for Jewish students to learn in her district. While not the only source of anti-Semitism, discriminatory curricula has been quietly creeping into California public schools for a number of years. It rose to new and alarming levels after October 7th, but even earlier it had been present. For example, Santa Ana Unified School District secretly drafted and approved ethnic studies curriculum that is explicitly prohibited by law. This particular curriculum developer strongly objected to the removal of anti-Semitic materials from California's final ethnic studies model curriculum and continued to develop and teach biased ethnic studies courses after the material was rejected and prohibited by California lawmakers. The teachings falsely equate Israel with settler colonialism, call Zionism a nationalist colonial ideology, and call for the creation and expansion of Israel as a Jewish state by any means necessary. The founder himself of this curriculum developer used social media to actively promote his anti-Israel bias and to widely disseminate anti-Semitic tropes. He's written multiple Facebook posts about Zionist control of California ethnic studies curriculum in response to a post reporting that an ethnic studies committee included a white Jewish woman. He responded on Facebook that Jews need to stay in their lane and claimed that the Zionist California Jewish Caucus has hijacked ethnic studies. While states and districts do have leeway to create their own curriculum and choose instructional materials. They do not have the leeway to teach state-sponsored anti-Semitism, which is what we're seeing. In Oakland Unified School District, a group of educators from the Oakland Educators Association drafted its own Teach Palestine curriculum and encouraged all of its members to teach this unapproved material at all grade levels and in all subject matters. In San Francisco, employees working for AROC, while organizing a blockade of ports and disrupting traffic by shutting down the Bay Bridge, accessed campuses throughout the district and organized school walkouts and protests for Palestine. AROC has also been involved in the creation of unauthorized curriculum in California. The narrative that Jews and Israelis are white oppressors, settler colonialists, without regard to actual history, has resulted in students viewing their Jewish peers as open targets of hate. After all, their teachers can do it. And one of the most heartbreaking things, Israeli immigrants and other Jewish families have moved to certain districts in California so that their children could be educated in what they thought was a discrimination-free environment where everybody would be included and accepted. The last thing they expected was the need to file complaints against their districts, where they once felt so at home not very long ago. What we're seeing today on college campuses did not start when the students got there. Many have been indoctrinated for years to believe that calls for the elimination of Jews is perfectly acceptable, even noble. Many believe they are just promoting social justice the way they learned from their teachers. While teachers have been claiming the right to protest, walk out of school, and litter their classroom walls with propaganda calling for the elimination of Israel, their actions are not protected speech. K-12 speakers do not speak for themselves at school or in school activities. They speak for the district. They do not have the same freedom of expression as professors have on college campuses. And the district has the obligation to make sure that the K-12 teachers are speaking in a way that is not discriminatory and doesn't foster harassment and bullying of the students. The districts need to be forced to protect their Jewish students.
Thank you, Marci and Mark. I'm going to give some remarks now about a Title VI complaint that the Brandeis Center filed against the Community School of Davidson in North Carolina. One of the things about this case that's notable, in comparison to what my colleagues have talked about, is that this case involves incidents that occurred before October 7th. And I think it's really important to remember that although there certainly was an eruption of anti-Semitism, really of historic proportions, both on campus and K-12 after October 7th, that this problem didn't start on October 7th, and that it goes back before that time. And so I just want everyone to keep that in mind, given the fact that this case, in fact, is one example of anti-Semitism that occurred in a K-12 context before the Hamas attacks on October 7th. So as I mentioned, in August of 2023, the Brandeis Center did file a Title VI complaint against the Community School of Davidson, which is a public charter school in the Charlotte, North Carolina area that receives federal funding. We at the Brandeis Center represent the complainant and her son, a former middle school student at the Davidson School. For 2 years, during the 7th and 8th grade, the student was subject to severe and persistent anti-Semitic harassment by his peers on the basis of his perceived Jewish ancestry. The harassment began after the student who is not Jewish wore the Israeli Olympic jersey of his favorite baseball player to school in the 7th grade. He was thereafter perceived to be Jewish by a number of his classmates. Since that time, the student's classmates persistently taunted and degraded him at school, referring to him as dirty Jew, filthy Jew, invoked classic anti-Semitic stereotypes about greedy Jews by calling him a penny picker-upper, invoked the Holocaust by saying, get in your gas chamber, go back to your concentration camp, go to your oven, Jew, the oven is that way, go die Jew. These are just a few of the vicious and vile anti-Semitic comments directed at the student while he was at school. When he tried explaining to the other students that in fact he was not Jewish, they dismissed him and responded with comments like, "Yes, you are Jew. Shut up, Jew, and go to your oven, Jew." Disturbingly, the harassment actually intensified during a Holocaust education unit in the student's 7th grade social studies class. Students imitated Nazi salutes, mocked and made jokes about the Holocaust. And around that time, the student discovered in the 7th grade bathroom a swastika that would have been visible to anyone using the restroom, and yet the school ignored it, didn't publicly acknowledge it or say anything about it. The harassment against the child continued into his 8th grade academic year. The group of students who participated in the harassment only grew. And we can surmise that this is because the school ignored it and it was fueled and enabled by the school's silence. His classmates target him at school, wherever they found him, in the classroom, gym, hallway, outdoors during lunch periods, and while playing sports on the field. The harassment occurred frequently, sometimes numerous times a day, and in the presence or vicinity of teachers and other school staff. Although it was aware of the harassment, the school did nothing to address it or stop it, and it continued relentlessly. In fact, the student was so distressed and isolated by the daily abuse and degradation he endured that he didn't even tell his parents about it for over a year and a half. However, his parents noticed something at the time. Something was different with their son. He started saying he hated school, that he didn't want to go to school. He was withdrawn. He wasn't himself. Ultimately, the toll of the daily harassment was too much to bear, and he finally did reveal to his parents what he had endured for over a year and a half. Upon learning about it, the student's mother promptly reported her son's mistreatment to the school. But thereafter, the student not only faced continued harassment, also retaliation for reporting to the school, and the school did nothing to address that and protect the student. The perpetrators called the student a snitch and threatened physical violence. The student was actually eventually assaulted several times at school by some of the same students who had been harassing him all along. The school here was clearly derelict in meeting its legal obligations to protect the student from unlawful harassment. The school did not intervene to address and stop the harassment despite knowing about it. It occurred in plain sight. And as explained by OCR's own guidance, the public nature of such harassment should have been, quote, sufficient to put the school on notice. And even after the student's mother expressly notified the school of the problems, thereby supplementing the school's constructive knowledge with actual knowledge, the school did not take steps to intervene, stop the harassment, or protect the child from threats of violence and then actually physical violence that occurred. Notably in this case, the school also failed to take meaningful steps to uncover and understand the nature and extent of the systemic anti-Semitism problem at the Community School of Davidson. There is unquestionably a school-wide problem at this school. The extended public harassment of one student by a fairly large group of perpetrators demonstrates a systemic problem that required a systemic solution. And yet the school failed to acknowledge the nature of the problem, let alone address it. And OCR's guidance is very clear that it's not enough even to just discipline individual perpetrators. Where there is a hostile environment, the school needs to take steps to address the specific steps that address the systemic problems, speaking out publicly about it, making sure that they condemn and label anti-Semitic harassment as such publicly, reach out to other potential targeted members of the community to find out if they are similarly impacted. None of this was done here. Clearly in this case, the student's participation in the educational opportunities at the school has been significantly limited by the unrelenting hostile atmosphere. As a result of this, his mental health suffered and his school days were consumed by dread, anticipating where would the next onslaught of harassment come from. Following threats of violence and actual physical violence, the environment became so hostile and unsafe that the child in the end was forced to transfer to another school to protect his mental, emotional, and physical safety and well-being. There are 2 points that I want to draw out here and emphasize just before I close. The first is that the fact that this student does not identify as Jewish makes no difference for purposes of Title VI of the Civil Rights Act. Guidance issued by the Office for Civil Rights, the federal enforcement agency in the Department of Education, refers to discrimination based on a victim's, quote, actual or perceived membership in a protected group. And it explicitly notes that a school is, quote, not relieved of its responsibilities under Title VI because the targets of one of the incidents was not actually Jewish. Here, the perpetrators made clear they were targeting the student because they perceived him to be a Jew. They first began harassing him after he wore a shirt to school bearing the name of Israel, the Jewish state, and referred to his purportedly Jewish ancestry repeatedly, even after the student insisted he was not Jewish. And the second point I want to make about this particular case is that this complaint that we filed with OCR has been pending for now since August. This is almost 9 months. This is a straightforward case involving persistent harassment of a child using classic anti-Semitic tropes and Holocaust trivialization and denial. This is not a complex case to understand, and it's a very severe and disturbing case of anti-Semitism directed at a child. This should be resolved expeditiously by OCR, and 9 months is too long. In fact, OCR has actually resolved a similar case with strikingly similar facts back in 2002 against the Kyrene School District in Arizona. In that case, it actually found that very similar conduct constituted anti-Semitic harassment and that Jewish students had been subjected to a hostile environment on the basis of calling students names like dirty Jew, filthy Jew, and stinky Jew, jokes about the Holocaust, making Nazi salutes, making disparaging comments about the student's ancestry, including references to concentration camps. Here in this case, you have all of these facts and more, including acts of physical violence against the student. OCR has explained furthermore in a Dear Colleague letter, in OCR guidance, that calling Jews quote unquote dirty and subjecting them to stereotypes about Jewish greed could create a hostile environment. Again, these tropes were used repeatedly in this case. Being subjected to daily discriminatory stereotypes and degradations, threats of violence, and actual violence invariably interferes with a student's enjoyment and participation at school. Certainly, this was the case for our client. Like all children, our client is entitled to learn in a safe environment free from racism and harassment. But instead, his middle school experience at the Community School of Davidson has been overshadowed by insecurity due to severe anti-Semitic harassment in a hostile environment. We would hope OCR resolves this complaint expeditiously by forcing the school to do what it has so far failed to do, and that is to come into compliance with Title VI by addressing the systemic problem in its midst and ensuring that no other child at that school has to experience what our client has been through.
Can I add a couple of things about breaking news?
At this time, I want to invite up the mother, our client, the mother of the child that I've been speaking about, who bravely would like to share some thoughts of hers.
Our collective attention has been on the existence of this in higher education recently, and rightly so, but I'd like to point out that our problem is actually deeper and more broad. This is affecting our younger children as well, elementary, middle school, high schoolers, and it is on the rise in the U.S. It is critical that we have responsible adults in our school administrations, educators that not only understand the seriousness and the danger of having a flourishing anti-Semitic environment at their school, but educators that are capable of taking proper action to effectively confront it and to protect children. What our family experienced at our school, the Community School of Davidson in Davidson, North Carolina, was the opposite. It would be hard to overstate the impacts that this has had on my child. The severe level of anti-Semitic harassment and bullying going on at his school were beyond what I have always considered to be bullying. I think that Denise shared some of those things. The list is too long. What went on there was relentless and brazenly out in the open, out loud, unchecked anti-Semitism, hate speech, and hostility every single day all over the school, with no adult to be found to intervene. It's been an unwanted situation for my child to have his life derailed by this, to experience an extreme level of hatred from others, and to be failed by the adults at his school. This was even happening in the school's Holocaust class, a Holocaust education unit. Yet they were simply unwilling to thoroughly investigate or address the severity and scope of it as a whole. At no point did the Community School of Davidson address the anti-Semitic bullying and harassment to any legitimate degree, let alone in a way to change the culture allowed to flourish within the school. Crucially, at no point did they keep my child safe. My son faced repeated retaliation, continued harassment, and an escalation into actual physical assaults. As a parent, this has been completely devastating. Watching my child go through this has been painful. Our family is dealing with the fallout of this, working to heal from what happened and working towards holding the school accountable for the actions that they took. It's been a year since we reported to them, at the time thinking that they would handle this responsibly and life would move on. It's been much longer since the bullying began, and we are still having to talk about it. It's really important to me and our family to speak out, to take a stand against anti-Semitism and bullying in K-12 schools in every possible way that we are able, and to hold the school's founder and administrators accountable for the environment that they created and permitted. But that certainly doesn't allow us to move on. It keeps things right at the forefront of your life, really. This has uprooted our lives. We've had to withdraw. We had to leave the school because it had become completely hostile and physically unsafe. At the Community School of Davidson, we really came face to face with an ugliness that would have seemed entirely implausible to me before this experience. Our family is not Jewish. I think it's really important to understand the fact that even perceived Jewish ancestry can land your child or family here. That is the climate that we are living in. Even just being perceived to be Jewish, or to be associated with Jews, or to be an ally of Jews, can lead to a personal experience with the long history and the sickening history of anti-Semitism. It did not matter that my son was not Jewish, and it had no bearing on the outcome. The effects are the same. The hatred and the verbal attacks resulted in the same distress. My son is just a kid that wore the Israeli Olympic baseball jersey of one of his favorite Major League Baseball players to school one day, and from that moment forward was treated with vicious and relentless hatred for being a Jew. So I know very well what can happen and what is happening to Jewish children in schools, and this cannot be tolerated for any child at all. I've seen an absolute failure of the school administration. As parents, we entrust these people with our children every day. That our kids should be safe in their care is basic. This is a given. No parent should have to send their child into a school where they are not protected in a physically dangerous situation, let alone where the actions of the educators themselves are contributing to an already abhorrent environment of severe harassment. Reporting bullying to administration should not mean a worsening of the situation, which is what we experienced. At the moment the school became aware of it, a thorough response should have been laid out and followed, an investigation, teacher training, talking with the community, looking at policies, whatever it took. And importantly, these adults should have provided an off-ramp for the students doing the bullying and the harassing of others with a severe degree of Nazi ideology and hate speech, and helped those students off of that path then and there. This was not done. What the founder of our school and the subsequent principal allowed was an environment where anti-Semitism intensified and grew. This is a school that presents themselves in our community as leaders in Holocaust education and as leaders in charter schools, but in reality was a place where my child experienced some of the most grotesque and extreme anti-Semitic harassment that exists. The reason that I've sought help from the Brandeis Center and filed a complaint with OCR really comes down to my belief that children should not be bullied in schools for their ethnicity or religious groups or any culture that they belong to or are perceived to belong to. And adults have a responsibility to protect them. It is crucial that educators get this right. Our kids that are suffering, our kids that are dying by suicide because of circumstances such as this, our kids that are perpetrating anti-Semitism or any other dangerous kind of hate themselves, they all depend on it, as does our society. Our goal here is to bring awareness to what is happening in K-12 schools, to alert both parents and educators and all of you, and to hold schools responsible for their actions. We need to try to help other children that are experiencing this, to prevent it from happening at all. I've always known that anti-Semitism existed, but had no idea the level of it until this personal experience, and it's made me determined to do whatever I can to stop it. It's something that I feel very strongly about, not just for my son and our family, but for all Jewish people. Thank you. Thank you, guys.
Thank you so much for your really powerful words, and thank you to your family for being here and for coming forward and really reminding us that this is humanizing everything that we've been talking about, and reminding us that the impact is very, very real. We're talking about children and families, teachers, administrators who are impacted in a very real way by a very, very problematic situation. I think Mark has some words that he wants to.
First, I want to just echo what Denise said. You know, as attorneys, we have to learn how to talk about this in a detached sort of way so we don't collapse from all of the horrible and depressing things. But when you put a real face on it again, even just for a moment, it's so sad. I'm so sorry for what's happened to your family, and I really hope that we're able to help you bring some accountability, and thank you for your bravery. It's rare that we get to do any kind of breaking news at a briefing like this, but today we get to do that. Part of the reason why I didn't want to give too many details about Origins High is because we like to let our court filings do the talking. And I'm proud to announce that about 15 minutes ago, our first lawsuit in that case was filed. I'm just going to read to you the press release. Today, Walden, Macht, and Haran and the Louis D. Brandeis Center for Human Rights Under Law filed a lawsuit against Origins High School, the City of New York, and the New York City Department of Education on behalf of a public school teacher and a school security officer. The suit accuses the city and other defendants of failing to address persistent anti-Semitism against teachers, including plaintiff Danielle Kaminsky at Origins High School in Sheepshead Bay, Brooklyn, leading to a hostile workplace. When the situation got so dangerous that a school safety officer, plaintiff Michael Beaudry, demanded action from the DOE, the defendants are accused of retaliating against him and removing him from the school. The suit describes acts of anti-Semitism and hate speech against Jewish people generally, and Kaminsky specifically, between October 8, 2023 and March 2024, which includes students marching through the campus chanting "F the Jews," aggrandizing Adolf Hitler, drawing swastikas on a Jewish student's property, and exclaiming to a Jewish teacher that they, quote, "want to kill all Jews." The complaint also details how school officials, especially interim acting principal Dara Kammerman, sought to shield the bigoted students from any disciplinary action, including against a student who brought explosives to school after engaging in other anti-Semitic acts. The complaint alleges that DOE's complicity caused the anti-Semitism to fester, and facing no consequences, that the bigoted cabal of students started attacking and assaulting LGBTQ+ members of the school community as well. Jim Walden, who's the attorney for Ms. Kaminsky and Mr. Baudry heading up that case, and an excellent, excellent attorney we're very, very proud to work with, said the following: "It is disgusting that these acts occur at all, let alone in a public school in the most progressive and enlightened city in the world. But it is simply shocking that DOE refused to protect its own people, and worse, retaliated against them to put a lid on the vile anti-Semitic behavior. Sympathizing with bigots only empowered them, allowed their hate to escalate, and eventually bubbled over to the LGBTQ plus community as well. This is a case study of how not to handle bigotry and anti-Semitism." And I'll just point out that in general it is true that anti-Semitism is often the canary in the coal mine of intolerance. It's usually a symbol of the rot festering within a particular community. With anti-Semitism on the rise, as cited in the complaint, the Anti-Defamation League notes a 140% increase in 2023 of anti-Semitic harassment, vandalism, and assault in the United States. In 2024, we've seen roughly a 388% increase. Meanwhile, public school teachers who were sworn to educate our future were met with inaction by administrators and the New York State authorities. The complaint was filed this morning in the United States District Court for the Eastern District of New York by Jim Walden, Adam Cohn, Mark Armis, and Stephen Gardner of the Walden, Mock, and Haran firm on behalf of their firm and the Brandeis Center. Mark Armis is actually here with us this morning if anyone has any questions for him after the conclusion of this briefing. But I just wanted to give you that update and share with you that we plan to hold the school and all of the other defendants accountable. Thank you.
Thank you, Mark. So with that, our panel is officially over, and we're happy to take questions from everyone. I just want to thank again our honorary host, Congresswoman Debbie Wasserman Schultz, and her office for enabling us to have this event, and everyone who is here today, including our clients who came from pretty far to be here. So we can take questions if anyone has any for anyone on our panel. Yes.
We've been seeing this rise in anti-Semitism related to the anti-Israel protests on college campuses. Are you seeing a similar rise in K-12?
Mark, do you want to answer that one?
The short answer is yes. We are seeing a very similar rise in K through 12. And I'll just take a step back because it's important to note this. Anti-Semites like to say that Zionism is only a political movement, and that's one of the reasons why we don't let anti-Semites define anti-Semitism. For the vast majority of Jewish people across time and space, Zionism is a part of their ethnic, cultural, religious, it's part of their Jewish identity. And it's fine to criticize Israel, but any form of anti-Israel activity or behavior that targets Jews or people who they think are Jews because of a real or perceived connection to Zionism is anti-Semitic. And it's also important to point out that, of course, Jews are not monolithic, and there is a tiny fringe part of the Jewish community that includes anti-Zionist Jews. But that doesn't change anything, and that kind of lazy tokenism is seen as unacceptable in other forms of discrimination. Just because you allow, for example, anti-Zionists into your protest doesn't mean that you're not anti-Semitic. It's the equivalent of saying that a person can't be racist because they have a black friend. It's widely unacceptable in every other context, and it's also wrong. So we are seeing the same kind of anti-Zionist anti-Semitism manifest itself earlier and earlier. I will tell you that I have had calls from parents talking about how their 5-year-old children, can you imagine a 5-year-old child is terrified to go to school because they are being physically harassed by older students? Yes.
Thank you, Mark. No. Yes.
You mentioned earlier the bill that was in the House about higher definition law. Just about that.
So the question was about the Anti-Semitism Awareness Act and whether, and what, I guess, what we'd like to see come out of it, what kind of impact it might have. I think I'll address this one to Mark as well, since he knows a lot about this bill.
Sure. Again, it's important. There's been a lot of misinformation about what this bill does and does not do. It doesn't create any kind of new protected class. It doesn't change any standard. It doesn't change anything. It defines a term in the context of Title VI, which only deals with behavior and not speech. And what it does is it says the following. If a person is targeted with unlawful behavior, and there's an allegation that the target was chosen because of a real or perceived connection to an aspect of a Jewish identity, the authority should consider as rebuttable, contextual evidence the world's gold standard definition of anti-Semitism. It is hard to imagine why this bill is in any way controversial. The only people I can imagine being opposed to it are those who were planning to target unlawfully Jewish people and don't want to get caught. Unfortunately, there are a lot of those people. And so one thing that's important to understand is that this standard has already been in place, as we discussed, since 2019. The codification would make it harder for people to make the argument that the water is actually muddy. It's not muddy, it's clear. The last 4 presidential administrations have agreed on this definition. All the bill does is say, you can say whatever you want, however abhorrent about Jews or the Jewish state. You just cannot then act on that hate and pretend it was not anti-Semitism. So we're hoping that it passes the Senate as well and is signed into law immediately.
Thank you, Mark. And thank you for that question. Any other questions for our panel? We'll be hanging around. If anyone who's here has any further questions, we're happy to speak with you and answer them. Thank you so much, everyone, again, for joining us.